I welcome you to all the participants to this e-manthan, which we are conducting now. This is the second part, and the subject is very simple. It's about the EPF laws and the gratuity laws and their interplay with the insolvency and bankruptcy code. So this is something that we are organizing as per the need felt by the Insolvency and Bankruptcy Board of India. Probably the what is felt is that the prefer to have more session, so that they can in the assignment itself they can make use of it. So and this is the second part. So I'll thank you for taking your time to be a part of this session, which we have called as e-manthan. We are also privileged and honored to have Dr. Sahu joining the discussion today. Sir, we welcome you today. Thank you very much. I also thank all the participants who attended the last e-manthan on this subject, which was held on 2nd of August 2022. And in case you missed watching it, so just for your information, the recording thereof is already available on our YouTube channel. You can go to it, which is ICSI Institute of Insolvency Professionals. That's what our YouTube channel is. So with that, I now wish to briefly introduce the speaker, Ravi Prakash Ganti, sir. Sir is a senior insolvency professional and a director at Resolve International Private Limited. With that, I once again welcome you, Dr. Sahu also, and I request Ravi Prakash Ganti, sir, to start his deliberations. Ravi, sir, over to you.
Thank you, Nitin. Hope you can hear me.
I can hear you, sir.
Thank you. Thank you. Okay. Last session, we basically covered the relevant provisions of the EPF Act, the Provident Fund Scheme, and the Gratuity Act in relation to how they will impact IBC processes, CIRP or liquidation. And we had discussed that in today's session, we will be now focusing on the interplay part. And how we will be doing it will be largely by looking at the rationale ratio of various case law on the subject, right from the beginning till date. I have chosen a few. Okay, there are many on this subject at various fora, whether it is NCLT, NCLAT, Supreme Court, High Courts. I have tried to pick up those which are which basically address the issue that we are trying to learn about. We will have this as a completely interactive session, as always. At any time, just use the raise hand symbol and you can ask a question or interject. We will also be covering the interplay of section 53. And specific questions too you can ask. My only request is that when we are covering each case law, you may only ask questions to the extent possible relevant to that particular part. And those which are of a general nature or very specific, we will come to at the end. Okay, we have just about 1.5 hours with us, and we will try to make the best use of that. Just a second. Okay. I hope you can see the presentation. Right, somebody respond?
Yeah. Yes, please. Yes, please.
Thank you. Thank you. Okay, so we start with the first.
We can see.
Yes, thank you. Thank you. So before we start the case law, I just want to put a hypothetical question or situation in your mind. Just keep it, park it in your mind, and we will be referring it to it at a subsequent stage. Okay. So consider that you have, each one of you, okay, this is a scenario building. You have invested in, let us say, public debentures of a particular company. That company goes into insolvency at some stage. And for some reason, the debenture trustee fails to file the claim or submit the proof of claim in time or to the extent to the satisfaction of the IRP, and the claim does not get accepted or admitted, or maybe sometimes the debenture trustee may not even file the claim. Now, just keep this in mind that there is a trustee who is supposed to act on behalf of the individual debentures holders, and these are public debentures, so there may be hundreds, even thousands sometimes. So, does that action or inaction of the trustee affect the rights, inherent rights of the underlying debenture holders? Okay. Also, again, I am saying by anecdotal evidence only that in almost all the cases filed at, whether it is at the adjudicating authority, appellate authority, or Supreme Court, almost all of them, it is the case has been taken up either by the RP or the liquidator, mostly opposing the priority accorded by law to provident fund or gratuity dues. Okay, just keep that in mind. Okay, and we will come to that. I just thought that in the beginning I will set the stage for okay. And now we come to the first case. Okay, now this is the oldest case of all. A lot of people would know about it, and at that time, and even today, I still consider this as probably the most recent judgment as far as the provident fund issue is concerned. So what does it say? This decision, the famous precision fasteners case decided by NCLT Mumbai as far back as September 2018, almost 4 years ago. Now, so I'm just picking up some of the points from that case, not the entire case as such, so that we just focus on the relevant issues. So what was the point for consideration? Whether or not the PF dues, provident fund pension fund due and payable to the workers or employees of the CD will become part of the liquidation estate in the light of section 36 of IBC. And then in the order, it says that from section 36 subsection 4A1, any asset, if any asset is lying in trust with the corporate debtor for the benefit of a third party, that asset shall be excluded from the liquidation estate. Now, this is the general statement at subclause 1. And then, of course, there is in subclause 3 where specifically the provident fund dues are mentioned. In this order, it says that it is an operation of law that when PF is payable to the workmen or employees, such payment dues have to be deemed as an asset of the workmen or the employees. Now, actually speaking, this is not even law is not required because this is simple accounting. You know, if I am the CD, my liability is somebody's asset, right? That asset is in the books of that party, it will be an asset. So if we drop the balance sheet of the employee, so for the employee, it's a receivable from the company. So for them, it is an asset. So it's not something new that is being created here. That, oh, you know, we keep saying that, how is that? Is it liability? Is it asset? It is just pure standard accounting principle. What is different, of course, as we go along, we will see is that the law tries to provide a different ranking to such dues. Now, this order says that it makes no difference whether it has been maintained in a separate account or not. And the workmen or employees need not prove that it has been vested in them. It is just that the operation of law, that in here the law is the EPF Act, that it makes the provident fund due as an asset of the workman or employee held in trust by the company or the corporate debtor. Now, this particular order refers to, this is a very important case and done and very elaborately Supreme Court has addressed this issue. This was, of course, in the context of winding up under the Companies Act. The official liquidator of SK Pharma EPF commissioner versus the OL. At section 11.2 of the EPF Act will have first because of that the dues to the employee but on account of provident fund will have first charge on the assets of the establishment and will become payable in priority to all other debts. Now the words all other debts have also been addressed, and we will come to that in another case where it has been explained what all other debts means. Sorry. Yeah. Now continuing in the same, it says that EPF Act is a social welfare legislation. Now this is also picked up from earlier Supreme Court judgments on the same matter, which have said so again and again, that the Provident Fund Act and to that extent even the Gratuity Act, these are social welfare legislation intended to protect the weaker section of society, and it refers to the directive principles of the Constitution. Okay. And we will come to that particularly when we look at the SK Pharma judgment. The same order, we are still at precision fasteners, that says that the rights of all other creditors are like property rights. Okay, every creditor to whom money is owed by that company. Now that is a property right in the sense that is the property of that property in the larger sense here, not necessarily immovable, but even receivables. Whereas PF dues are of the workmen are interwoven with right to life. Now, this is one of the first times that it has been so explicitly said in any judicial forum that Provident Fund dues are equivalent to right to life. Now, we had addressed this or looked at this statement and this viewpoint in the last session as to why Provident Fund is looked at like as equivalent or related to right to life. And it is there in the first word itself, provident, to provide for. It is not treated as a claim on par with other creditors. It is in fact to be treated as an asset of the workman lying with the corporate debtor. Now, all the liabilities of the creditors, the corporate debtor, they are to be subject to proof of claim in any insolvency or liquidation process. Now, this is also a claim, obviously, but what Section 36, read with the EPF Act and others, the order is trying to say is that it is not to be treated similar to any other claim. Yes, it is a claim, but in the nature of an asset of the claimant lying with the CD, which means that it has to be returned. It is not to form part of any pool for general benefit. In this particular case, they have addressed this question where the applicant liquidator had said that Section 36 actually deals with money which is already there in certain fund, which in this case they were talking of the EPFO fund. Almost 90% or more of all establishments in India, they contribute to the fund established by the central government. There are very few companies who fulfill the eligibility criteria and run what are called exempted funds. That means they run it themselves. But the principles of running both the funds under the Act are same. It is just that the board of trustees will be different for each. Now, in this case, the liquidator had tried to argue that the wording of this section says that due from the fund. So I don't have a fund because there is no money separately kept as a fund by this CD. So nothing is due. That means Section 36 here does not apply. Okay, there is nothing called priority because whatever it is will follow the waterfall mechanism, including 1A or 1F, depending on where it falls. Now, the adjudicating authority said, no, sorry, this is not the way it is to be understood. Because just because it is due and payable by the CD, it is not kept at, or on par with the state. And the movement, the money from towards the provident fund becomes due and payable by the employer whether it is employee's contribution or employer's contribution. And we have looked at in the last session that the employer is obligated to pay both contributions to the fund, I mean the EPF or the exempted fund, firstly, and then claim it from the workman. It can be simultaneous, but the employer is not absolved from not remitting the workman's contribution also, or the employee's contribution. So once deduction has been made, it becomes the asset of the workman, and it is no longer an asset of the corporate debtor. And where deduction has not been made, we have seen that in the last session, that let's say the wages have not yet been paid. So obviously there is no deduction at that stage, because no deduction can be made when the wages themselves are not paid. Even then, to the extent that from the wages payable, a certain amount is due to the provident fund as deduction, and from the employer as the employer's contribution, they still are to be treated separately as an asset of the employee being held in trust by the employer. Coming to the end in this order, it says that, be that as it may, this was the issue where the PF department had issued attachment orders on the assets of the CD, and that's why the liquidator had gone to the AA. The adjudicating authority held that liquidation process shall continue, but the liquidator shall be bound to pay the dues under the head of PF, pension fund, gratuity, depending on what is there, in priority to the waterfall mechanism. That means that these are to be not to be treated as the liquidation assets available for distribution under 53. They are payable in priority above 53. Okay, we have also discussed whether CRP cost will be above this or equal to this and all that. And we have concluded last time that yes, CRP cost also has the same priority. That means they need to be payable together. Of course, we have not yet addressed the situation where the money is not enough to pay both, but I think that we will leave it to the judiciary when it comes to that. Okay. So at that, in this case, what the bench held that the liquidator shall carry on the liquidation. The attachment on the assets will be deemed to have been vacated, but the charge, the first charge of the provident fund dues shall continue to remain in force, which means the charge is there. It is equivalent to any other charge, except that this is a statutory charge and has been held to be in priority to any other charge. And hence the petitioner, in this case, the liquidator, is directed to pay all the dues of the workmen or employees from the in relation to PF, gratuity, etc. And the respondents, that is the Provident Fund Department, is directed to allow the liquidator to sell the asset. That means to treat the attachment order as withdrawn. So this covers the first case, the first landmark case on Provident Fund dues. Any questions at this stage? It's a very old judgment, probably everybody would be aware of it. So shall we proceed to the next one?
Yes, sir. Nicely presented.
Sir, what about the interest on PF and the damages part? How is that to be treated?
We will come to that. There is a case law which will cover that part too. Okay.
Thanks, sir.
Wait. Yeah. Okay. This one is a appellate tribunal order of August 2021, just about a year old. Similar thing again, here it is, of course, the PF department, which is the appellant. Section 53 of the IBC is not applicable for PF. Okay, this is what is their thing. The appellate tribunal has agreed, saying there is no dispute with regard to that. And we are in agreement with the said position of law that Section 53 of the IBC does not come into picture where provident fund dues are concerned. Okay. Then they are referring to another judgment of that bench, which we will cover next, It's just that it has come later. No provision of the EPF Act is in conflict with any of the provisions of the INB code. Now, this is what the NCLAT has said. There is no conflict. It has to be harmoniously interpreted, that both shall survive. Okay. Same 36, section 36, subsection 4, A3, Provident Fund, Gratuity Fund are not assets. And the question of referring to section 238 does not arise because it has been held that there is no conflict. Both can coexist in the manner interpreted. Now, whatever we are seeing under IBC as relates to PF dues primarily and to some extent gratuity is nothing different from what it was under the Companies Act, winding up under Companies Act. There are a number of judgments on the same issue which have been held over a period of time, and largely speaking, okay, there are certain judgments or orders which have a flavor of conflict with whatever has happened before, but largely the trend is that yes, Provident Fund dues are to be paid in priority to everything else. Another case again at NCLAT, November 21. Now, in this is a funny case where this is about a resolution plan. In this, the resolution plan mentions that there are pending dues towards PF, ESIC, Labor Welfare Fund, etc., for which no claim is been submitted. Now, this is a very common problem we all of us face, that it is not necessarily common for government departments to submit their claims in time. Many times they don't submit at all. Sometimes they do, and many times it is late. But that is what it is. Now, the resolution plan here said that though claim has not been submitted, they shall be paid in full on an exceptional basis. Okay, that's what the plan says. Now, in this case, the PF department was told, sorry, you have not filed a claim. You have not brought anything on record to say that you have filed a claim. Neither have you even produced any evidence to say that you have approached the adjudicating authority who has directed that your claim shall be accepted. So we have to, that means the appellate tribunal said, we have to accept the submission of the RP that no claim was actually received. Okay. And the claim of 2 crores, etc., that you are submitting, supposedly submitting by way of email cannot be accepted. There is a problem with this judgment. Okay. And please refer back to the first scenario that I requested you to think about, the debenture trustee thing. That was just to put into context, easier context for most professionals who may or may not have had anything to do with the Provident Fund issue in their lifetime. Okay. So in this case, the appeal by the EPFO was dismissed. Of course, the plan specifically said that though claim is not received, we are paying it in full. So probably what one can understand is that based on the data that is available in the order, that the PF dues were satisfied in full. So the dispute did not remain to that extent. Now we come to January 22 judgment of the Allahabad High Court. This is also filed by the liquidator of LML Loyo Machines, the scooter people, okay, which was into CIRP and went into liquidation. Here, the background behind this was that at some point of time, this company had laid off its workmen somewhere in 2007, okay, on 15th April 2007. And the workmen union probably went to the industrial tribunal, which ruled that the layoff was illegal and that the workmen are entitled to complete back wages from that day the so-called layoff came into force. Now, this was the order of the industrial tribunal. Of course, this happened, I think, in 2020. Okay. Now, liquidation order was passed in 2018. So it is after the liquidation order was passed. The question of moratorium was addressed, and the High Court said, yeah, once liquidation order is passed, the moratorium under CIRP ceases to exist. So the Industrial Tribunal was well within its rights to issue such an order. The High Court also looked at what will be covered and where in terms of the priority accorded under Section 53, and very clearly said that at the top, that is at 1A level, in creditors with dues to secured creditors, only workmen's dues of the previous 24 months shall be treated there at that level. And any additional dues of in terms of back wages or wages for a prior period. Now, in this case, because there was a layoff and for years wages had not been paid, and they said that back wages have to be paid. So all that will need to be considered. The High Court upheld the order of Can you hear me? Yeah, sorry. So the High Court upheld the order of the Industrial Tribunal as legal and valid, but said yes, taking into account the framework of IBC, that Section 53 shall apply as far as that part is concerned. 24 months wages shall be considered as priority. The rest will come at a much lower level. The liquidator had said that the Industrial Tribunal order, he was challenging that order itself, saying that there is no material placed before the tribunal that the people who had been laid off had not engaged in any gainful employment, and hence they should be reinstated or back wages should be paid. Now, this is part of the Industrial Disputes Act, that if a laid off employee is engaged elsewhere during that period, then such employee cannot claim full back wages if the layoff is declared illegal or otherwise. The High Court said, sorry, I mean, this is not the way it works. Okay. It is for the company to prove that they were engaged elsewhere at that time, or somebody third party to prove. The workmen or employees do not have to leave negative evidence that they were not engaged. Okay. So being engaged, being of a penal nature in the sense that you will get less. So it is the other side who is making that charge to prove it, and not for the workmen to say that they were not engaged elsewhere. And they were also, okay, some evidence had been presented by the workmen that they were attending the head office every day, etc., etc. So all that was looked at to uphold the legal validity of the back wages order, subject to Section 53. Another prayer of the liquidator or the argument was that the list of workmen had not been furnished by the union, to the extent that whatever they claim they are making, no list has been given by that. The High Court said again that no, this omission does not come in the way of their entitlement. It also looked at the records placed before it and said that only 2016 people had actually made claims, but the liquidator had provided, based on records of the company, for 6,337 workmen and employees, which itself goes to show that all the data was available with the liquidator. So this argument that now was being raised by the liquidator was not to be acceded to. We have covered this, that Section 53 will apply to the extent that 2 years wages will be considered at the priority level and balance will be at the bottom. Okay. Now that largely dealt with wages, etc., but also, though it doesn't strictly cover PF in that sense, but I included that because it does have an indirect impact of what happens during liquidation. Now we'll come to this 11th March judgment of the appellate tribunal, and this is now what in every other order they quote the Sikandar Singh Jamwal applied electromagnetics judgment. Now, this is again of a resolution plan. Okay. The resolution plan had not taken into account the payment towards Provident Fund dues as computed by the Assistant Provident Fund Commissioner by way of its order. Okay. Order dated 19th March 2019. The resolution plan having been approved on 2nd April, which means roughly about 10 to 11, 12 days after that, appellate tribunal took the view that it ought to have been factored. Okay. That once it is known that certain liability has come in or at least crystallized by way of an order, that should have been taken into account. So instead of 1 crore 35 lakhs odd, which was what the order said, only 78 lakhs had been provided for. The tribunal was then referred to section 30, subsection 2E, that the resolution plan should not, and there is a typo in the order itself, so I've corrected that, should not contravene any of the provisions of the law, which means that section 17B of the EPF Act also cannot be contravened. And now comes the interesting part. Now 17B, what is 17B? 17B of the EPF Act deals with the liability of the establishment in case of a transfer of the establishment. Now, how does that work? Okay. And it says that the employer, that means the existing employer, which in this case would be the current management of the corporate debtor. And we have seen last time that employer under EPF Act is always an individual, not a body corporate. Individual as designated, all those we have looked at. So the employer and the person to whom the establishment is so transferred. That means in this case, the RA, okay, jointly and severally shall be liable to pay the contributions and other sums due. And other sums due here means actually all that thing, the interest, the damages, if any, everything, in respect of the period up to the date of such transfer. So when an establishment gets transferred, then the liability also falls on the person acquiring that establishment, if it's a new management, with the provision that such liability shall be limited to the value of the assets. That means no liability which is higher in value than the value of the assets acquired. That's standard. You can't be buying negative assets, right? So this is what the second applied electromagnetics order says, that even on transfer, the liability continues unless it is explicitly mentioned and dealt with in the resolution plan within the parameters of IBC. So non-mentioning of it and not addressing it in the plan would mean that the entire liability will come up on the RA. Same thing, all under the Act, whatever is the contribution and any other sums due shall be payable up to the date of such transfer. NCLAT is saying that explicit provisions of the EPF Act need to be complied with. This is not commercial wisdom, as compliance of law is a must. So one has to understand what is commercial wisdom, really speaking. In fact, to my mind, commercial wisdom means that which affects me, not somebody else. I can decide for myself. So in a COC, the COC as a whole can decide for itself. It can't, for example, decide that somebody else will be paid less and they will be paid more, unless the law says so. So commercial wisdom really is that, to decide which plan out of 3 or 4 is better, which maybe some plans sometimes give options, which option a particular creditor will choose or not, the financial creditor. But commercial wisdom does not extend to deciding the rights and liabilities of other parties. Okay, that is really what is trying to say. The compliance of law is a must, and does not fall under commercial wisdom. Again, reiterating, no provision of PF Act is in conflict with IBC, so applicability of Section 238 does not arise. PF dues, okay? It's saying PF dues. Sometimes we keep getting confused. Dues means Provident Fund or payable to Provident Fund or from the Provident Fund, okay? So are not the assets of the CD. Again, whatever we have already looked at. So the order finally directed the RA to release the full Provident Fund dues in terms of the provisions of the EPF Act. So that was that judgment. Any questions there? If anything is written in chat
Yes.
box, I have not read.
Yes,
Yes, Mr.
Hello.
Bhatia, go ahead.
Yeah. Sir, in LML case and this last one, allied cases, in allied cases, they are saying you have to comply with the law. So you have to pay the PF in priority in applied cases. And in LML, the High Court is saying that you have to pay as per the Section 53. It means for the laid off employees or workmen.
No. Okay. Let me clarify that because I did mention this. Maybe you probably missed it. The LML judgment was largely dealing with back wages, not PF.
Dealing with
back wages.
Okay.
Okay,
Yeah.
not PF.
Okay.
I said that I was including that, though it did not directly deal much with PF. Just to tell that, post liquidation order also, proceedings can continue, moratorium doesn't apply. Back wages are to be treated. But what the actual order put up is that it distinguished between what is under 1A and then what is under 1F.
Okay.
So 2 years is 1A, balance is 1F.
Yes. Okay.
It was just clarifying that part.
So they are not talking about the PF payments and all that. That
no,
liquidator has to take care. He
Yes.
has to deduct and all that.
Yes.
Okay.
PF.
Thank you.
Yeah, that judgment doesn't.
Just one more question. In this case, like laid off cases or termination cases, so liquidator has to calculate the PF from the back
No,
date?
this LML case was where the layoff was declared as illegal by the appropriate authority, which is the industrial tribunal.
Yeah.
Okay. Whether if something is legal or illegal, the appropriate court or authority will determine. Okay. Liquidator has no such power. So if the layoff is legal, let us say, that means till the date on which the distribution has to be made, no order has been received by the distributor and by the liquidator about the legality or otherwise, then one has to consider that it is legal, unless set aside any action to be taken as legal, unless there is a pending notice or a pending case, which means if there is a pending case filed by the workman or the union challenging the legality of a prior layoff order, then one has to probably go to that authority and ask, what are you deciding? Because liquidator cannot decide. Adversary can go and say, I have to finish my liquidation and please tell me, what is your judgment? Okay. Yeah, Mr. Navanda.
Sorry, if in this case, if the back wages is considered as legal, layoff is considered as illegal, then back wages are payable. Though under 53 where it falls is A or F. But then
No,
the
A and F.
A and F. But then
2 years,
provided
previous 2 years will be A. Anything beyond.
My question is that if the back wages are payable, then once the wages are payable, the provident fund on that is also payable.
Absolutely.
So, the provident fund will always fall beyond 53.
Absolutely.
So my understanding is okay.
Absolutely. Perfect.
So back wages might not be, the worker may not get it, but he will definitely get it the PF dues.
Yes. Because PF is a statutory obligation considered to be equal to right to life. Okay. Only one judgment has said so. But if you look at the theme of many Supreme Court judgments, they do refer to directive principles of state policy which touch upon these aspects also. Okay. Any other question?
No, sir. No, sir.
Thank you.
Not from my side.
Yeah. Anybody else? Or shall we move?
Yeah,
We will always come back. We are here.
one question.
Yes, somebody was saying something. Yeah.
Raviji, yeah, this is Rekha.
One question is with regard to
Hello. 1 second. I think Mr. Taneja, did you say start first? Rekha will come back.
Yes.
To you.
yeah, no problem.
basically
Mr.
if there is
Taneja.
no claim from any workman and there are dues from the EPFO, then there is no workman who is claiming any amount, and EPFO is claiming the entire amount on the basis of ex parte order. So
Okay.
how it is to
Who
be
makes
dealt
the claim? Okay. Now that is why I said I will come back to this issue, because again, I ask you to think about a scenario. There is a debenture trustee. You are a debenture holder, and maybe you are not aware of it. Okay. And the debenture trustee has not filed a claim. Is your right extinguished because of that, or should it be, or how should it be treated? We will come back to that. Okay, good question, but we will come back. It's very, very important. That's why I'm keeping it for a little later stage. Yeah, Rekha.
Yeah, Raviji, in case if the accounts are not maintained, say for last 3 years, 4 years, whatever, and prior to that, the PF liability is shown in the previous financial statement, audited one. But last 4 years, we do not know what is the liability and the details of employee. But however, some of the employees are continuing, the liability is not booked. Is it a RP or liquidator's role to calculate the liability and then make a payment as a super priority?
Yeah, okay. If you refer back to last session, you were there.
Yes.
So we had discussed the employer concept. What does an employer mean?
Yeah.
Whether the RP or the liquidator. Okay, liquidator is different because by then normally employees are supposed to be discharged in most cases, barring a few rare cases. But RP, okay, that's the more common one. Does the RP then become the employer? Yes, it does, in the sense that because the code itself says that RP shall comply with all laws. All laws includes EPF Act. EPF Act says the person in control is the employer, and employer is liable to maintain record data, whatever it is, pay the contribution towards the PF.
Yeah, got
now
it.
the question will come, to what extent you are able to calculate it. That's different. Okay, that is the mechanics of crystallizing that liability, and that you can fall back on the I think it's then the regulation which says you will make the best estimate based on the information available, unless better information becomes available at a later stage. So if the employees have not filed it, and if you are going to, okay, if you are talking of a CRP which ends in a resolution, now they're slightly bit tricky, because it could be that 17B will apply, and unless the resolution plan very explicitly says this is what the claims received or intimated to me by the RP, and so I'm making that payment and I'm not liable for anything else. If at all, somebody else should be liable. That somebody else, now again, employer under the PF Act being an individual, will be the old management.
Yeah.
Okay, it could be the old promoters. They will become personally liable, because the person who has not made arrangement to pay the contribution when he's so required to do, that person becomes personally liable to the
yes.
PF commission.
Yes.
So that's how the interpretation.
Okay, yeah, got it. So 17B basically, when we look at it's a PF dues, which includes even the additional interest, not only the contributional related interest, that is 12% each.
It is four items.
Yeah, and the
employer's
damages,
contribution, employee contribution, delayed payment interest, and damages by way of
yeah.
penalty.
Perfect. Yeah.
The PF Act allows waiver of damages.
Yes.
We saw that, right? Up to 100%. That means complete damages can be waived. So this is what an RA should actually do. See, RA has two options when making his plan, right? Either he can say that, okay, I will be saying it before the part comes. We will come to that when
Yeah.
section 53 we are dealing with.
Yes.
Okay.
Yeah.
Yeah.
Thank you.
Okay. Now on gratuity, not to the best of my knowledge, this is probably the only explicit order. There may be others that I am not aware of, but this is a very old one.
So Ravi
And,
sir, there is some
but
disturbance in voice. There is some disturbance, lot of voice is coming from, I don't know, from your end or from others.
not from my end, no noise. I am totally alone. So must be somewhere else. Somebody has a mic on. Please request everybody, keep your mics on mute. Nitin, have a look in case anybody's mic is on. Please mute them.
There is some disturbance from outside. Your voice is breaking.
I think some part of the voice may be network, right? I am seeing my video very clearly. So it could be somewhere in line. But if you are totally unable to hear, ask me, I will repeat.
So we are able to hear you. It's just a cracking noise.
Okay. Okay. Right. So on gratuity, this is the one order that I am aware of NCLAT, February 2020, more than 2 years ago. In this case, the adjudicating authority had told the liquidator that you shall pay gratuity. Okay. And the liquidator again went to NCLAT on the same grounds that the company does not maintain a separate gratuity fund. So I can't make payment because it doesn't exist. And AA said you have to make provision for that money. So this is what went to NCLAT. NCLAT observed that in the annual cash flow statement of that 2017, this was probably produced as evidence, the balance sheet and annual report, that a gratuity fund was proposed by the company, but was never created. Now, what is a gratuity fund? We have looked at last time that it is actually maintained with the life insurance corporation, right? By way of a gratuity insurance policy. It's not actually kept in the company. It has to be maintained with LIC. But though the act says it is mandatory, it has left it to state governments to implement it, and most state governments have not done so. That's why you'll find that most companies, most employers actually don't have such a fund. They say jab aayega, when the liability actually becomes payable, not on an accrual basis, but when it actually becomes payable, that time we will pay, so that the amount of money payable probably is not that much. Be that as it may, this was that such a fund was proposed, it was not created. So the NCLAT held that liquidator should not have been directed to make provision for the payment of gratuity. This is the, as I said, this is the only one that I know of on gratuity. But taking the cue, because gratuity, PF and pension have been dealt with in the same subsection of the IBC. And all the jurisprudence, I mean, all the case law prior to that, or even after that, when dealing with PF, has held a certain position on what is the priority and when does it become payable. So to that extent, this particular judgment may not really stand the test. I mean, what I would say, it is not necessarily good law as of today. NCLAT Chennai, relatively recent one, in fact, very, very recent, 2nd June 2022. Continuing on the same way, the same thing they're holding that they're referring to Maharashtra State Cooperative Bank Limited versus PF Department is a 2009 judgment, almost upheld in entirety in terms of the rationale or ratio in that judgment in the SK Pharma case that was of 2011, 2 years later. So penal damages and interest levied by PF authority under 14B and 7Q. Somebody asked this question. This is what I said. Wait, under 14B and 7Q would form part of any amount due under section 11, subsection 2, which means first charge on the assets of the establishment. Okay, in this case, the corporate debtor. Okay, so that means they will not be part of the waterfall mechanism. Yes, Mr. Lundar.
Since these dues are like, as per this judgment, PF authorities are entitled to the satisfaction of the full claim. Now the company is under CRP and it's, carrying on the operations, and the PF commissioner passes the order for, determining certain liability as PF, and also, interest on the, let's say, delayed payment of, PF contribution.
And damages. There is a third component also, damages.
So,
it can be three parts.
So is it that, and it pertains to the period prior to the CRP, commencement of CRP. So should RP pay that amount of interest?
Who is RP to decide what shall be paid or not? RP is not owner. RP is not an interested party. RP has to comply with all laws. EPF Act is a central act applicable throughout the country. So it is applicable on that RP. On what basis RP will say that I will not follow this law?
No. All that I'm asking, sir, is that since that it is for delayed.
In any case, RP doesn't pay, right? It is the RA who will have to provide for it in a resolution plan.
No. Not RA would come later on once the resolution plan is approved by the adjudicating authority. Right now, there is a RP is there.
You mean and during the period of the CRP when RP is running it as a going concern, whether it should pay that first or not? That's a business decision depending on what amount of money is available, right? If the money was available to pay everything, including PF, it would probably have been paid before. So unlikely that that situation will come where the RP will say, yeah, okay, all the PF also I have the money to clear it. I'm going to do those. It doesn't happen, right? Practically.
No, it is.
There would be.
I'm sorry.
Payment and liability are different. The liability exists. Whether RP shall pay out of current cash flows, that depends on what is the current cash flow.
Absolutely. So suppose if the cash flows are there, but the question is that the interest pertains to the period prior to the commencement of CRP.
Okay. Okay. First, let us get it clear. That's why again I will go back. Okay, I will not answer this now. I will still want to answer this in the broader sense. But look at the same example which I gave in the beginning. Probably you joined late. That if you are a debenture holder of public debentures of a company and your trustee fails to take action in insolvency or what, right? Are your rights hampered because your trustee didn't work? Okay, we will come back to that. I will answer this because this is the core question, right? So to say, we will come back to it. So we'll just finish a few case laws which are left and then we'll come back. Okay. So this recent Chennai, NCLT Chennai holding up the same thing, that all dues are payable. Now 7Q, which is interest, and 7A, which is the basic contribution, these actually are the what goes into the account of the member of the fund, because delayed interest would mean, because the member, the employer not having paid, the member has lost out. Otherwise, the PF trust would have paid that interest, right? Or dividend, whatever they call it, on an annual basis. So that being lost out, you have to pay that. Okay. 14B, which is damages. Now, damages is a penalty levied by the trust, which doesn't go to the member. Okay, so keep that thought in mind, how the three are different. So two of them are really assets in trust of the employee. And the third one is a penalty for default by the employer. And that is a penalty which is laid by statute. Okay, it is applicable even for exempted funds. Okay, to that, but it has to be paid to the government in this case. So keep that word in mind, government, and the answer will come soon.
Raviji, in that
Haji.
case, when this interest, additional interest,
We'll come. Section 53, I'm going to cover. Okay.
yeah, I was just to, yeah.
I
Okay.
told you last time, we will cover that. You know,
Yes,
where
yes.
does it come?
I
So,
have a practical question. Probably I'll ask in the last. Okay.
yes. You will, all questions we will take.
Okay.
Now, this is cases Petron, very, very fresh, right? July 2022, as recent as it can get. Now, this is a bit slightly different. This is about an order or orders, series of orders, 7A, 7Q, and 14B orders issued by the EPFO, okay, on the liquidator after having filed a certain claim prior to that, which was admitted by the liquidator. Okay. So keep that in mind. This is how it happened, right? Now, the RP had admitted the claim, which was 47 lakhs something odd figure, which was filed by the Provident Fund Department. Then the PF Department initiated an inquiry under Section 7A. Okay. The RP informed the department that CRP has commenced now and moratorium is in place. So you cannot continue with your inquiry. Now, this is the RP's view, okay, that Section 14 prohibits all types of proceeding. And basically, we'll cut to the chase. The adjudicating authority held that yes, the okay, we will go in the way it is there. Now, two challenges which were made by the applicant, that the orders and notices under challenge passed in violation of the moratorium. Okay, that is the first challenge. And the inquiry under 7A has no basis. It is a roving inquiry, fishing inquiry with, as per the data available with the RP liquidator, that no outstanding liability was there. Whatever was there had already been admitted during the CRP period. The orders are vague. They do not even have details of the employees, employee numbers, nothing. I mean, it's just, this is the, what were the arguments of the liquidator. Okay. The respondent, the department says that, sorry, this is not covered under the proceeding, the word proceeding under Section 14, because this is in the nature of assessment, crystallization of liability. It is not a recovery process to that extent, in the sense that only after completing this inquiry and arriving at that amount, which is due and payable by the establishment, that is when the PF department can submit a claim. And they need to complete this, because that is the method by which it is done. And why would that be? There is an argument that which is not clear from the order, but I would assume that this is what they have said, that the fact that the company has not been paying or submitting returns over a period of time, which is it is obligated to do, then obviously the PF department doesn't have the data to arrive at what should be the claim as on today, as on the CRP commencement date or later on the liquidation commencement date. And hence they need to conduct this inquiry. This is nothing except an assessment proceeding. The second argument they made, yes, that it should be payable in priority to all dues. Okay. The adjudicating authority said, first let us look at the legality of the orders and notices, recovery notices that have been issued, and the applicant, as on date, that means the liquidator said that no claim has been submitted by the EPF authorities. They have only issued orders. Now the liquidator is trying to distinguish between claim and order, recovery notice or recovery order, by saying that claim is that form. Okay, if it is not in that particular format, then it is not acceptable. So this is procedure being touted as an argument that because of that I can't even accept it. So your order is in violation of the moratorium, number one. Number two, it is not a claim. Okay, both these arguments are made. And if such claim is made, then it shall be dealt with accordingly as per the code. Okay, that is at the end. Yes, the liquidator also challenged it, saying it's a phishing inquiry. Details are not there. Names of employees, PF numbers, nothing is there. The liquidator also said that, dues from the PF fund are payable and not dues to the said fund. Now, this from to we have looked at when the section 36 talks of dues from the PF fund, from the gratuity fund, and liquidators or IPs in general have taken the stand. We don't have that fund with us, so we are not liable to pay. Okay. But courts have generally held that that is not how it is to be understood. Okay. In fact, the first order itself on this, the precision fastener order very clearly says that the whole question of paying from the fund does not arise because the fund is anyway never with you. If you, as an employer, have contributed and deposited the money with the EPFO, it is with them. Where is the question of that being with the company? The company loses all rights on that money. It is so protected that even a decree of a court, even a criminal court cannot attach that money. So the words from have to be understood in a different manner, not in the very pedantic, very literal meaning that I don't have a fund, so I'm not liable. No, that is not what it means. Now, cases pattern, coming back to that, section 14, the AA says that there is a complete prohibition on the institution of suits or continuation of proceedings. The court does not differentiate between any proceedings. All proceedings are proceedings, whether they are assessment, quasi-judicial or judicial. So the moratorium shall apply. It also goes on to say that the proceedings initiated by the PF department under section 7A, they are not mere assessment proceedings, because the act itself states that they shall be treated as judicial proceedings within the meaning of section 193, 228 and 196 of the IPC. So to that extent, they are also hit by the moratorium under section 40. And since damages can also be imposed, that would impose a pecuniary liability on the company under CIRP, and that is prohibited. That cannot happen. So the contention that they are mere assessment proceeding was rejected. Claim which is not alive on the insolvency commencement date. Now this is a bit controversial here. This is that if a claim is not crystallized on CIRP date, then is it to be treated as not alive on that date because the crystallization not happening could be because of the fault of the corporate debtor itself. But the AA is saying that this was not a claim which was there on insolvency commencement date. You had calculated it subsequently, though it might pertain to a prior period. So it cannot be indirectly permitted to be ascertained. The contention of the PF department that these are social welfare dues and their actions taken for the benefit of employees is all fine, they say. But again, question is that the orders do not provide the details. So to that extent, we can't accept it at face value. Some number calculated in some manner cannot be taken. It has to be specific member wise. Fair enough. I mean, that's what, otherwise it's not a verifiable claim. And section 36, yes, protects the social welfare dues of the employees and workmen. But they need to be relatable to specific employees. It can't be some general number. So yeah, liquidator has said that these are orders passed in days without identifying the names, and that contention was accepted. But finally, it states that having said so, that means having said all that, that moratorium applied, the orders could not have been issued, the proceedings could not have been continued. However, because these are priority and protected dues, So while the orders are being set aside of the PF department, the claim or the right of the employees concerned will not be extinguished or adversely affected in any way, and they can file claims even towards whatever PF dues are payable to them in case they have not already done so. And the liquidator is duty bound under law to accept, ascertain, and prioritize the payment of the social welfare dues. So the priority and ranking is being ducted. Only the order of the PF department recovery orders are being set aside because they are, what you can say, unverifiable. So no opinion on the merits of the order being set aside only because of moratorium. We had referred to oil versus oil of SK Pharma, PF Commissioner versus oil, and these are some of the statements made as part of that order. So I will not go through this in detail, but it refers to Article 38 and 43 of the Constitution. These are directive principles of state policy which deal with social obligations of the state, as well as how the state should take care of workmen in general. Okay, specifically they are mentioned. This Supreme Court judgment in SK Pharma defines all debts to include all debts, which means that when 11.2 says these are payable for all other debts, they include the debts due to security interest. That was the issue in that case. So said yes, this stands above that. Okay. Joint Committee of Parliament, which is the one which actually brought in this section 36(4)(a)(3), and that was because of a representation by the EPFO, which had said that the draft bill at that time when it was passed had effectively negated what was the law prior to that, because that was protected under section 326 and 327 of Companies Act, and those IBC had said will no longer apply. So the new section was proposed. It was now just the history of it tells that the intent of Parliament was to bring back the position that PF dues and gratuity and pension enjoyed under the winding up under Companies Act by way of a separate section under IBC. So there is a continuity between the two. It is not that this is something very different from that. So this is that famous section, all sums due, section 36(4)(a)(3), those which shall not form part of the liquidation estate. All sums due to any workman or employee from the Provident Fund, the Pension Fund, and the Gratuity Fund. Now here, okay, here after this coming to 53. So let us look at this. This is the one which has I think been probably not as well understood as it ought to be, the intent behind it. And a lot of us have fallen prey to a literal interpretation when we see the word from the Provident Fund. What do we mean by from? And in the case of PF gratuity, etc., the companies never actually have funds. I mean, they don't maintain a fund. Even if it is an exempted establishment, it is allowed to maintain it only as per the scheme, which means that it shall be a separate fund by itself, managed by a separate board of trustees, who will include representatives from the employer and the employees both. But it is separate. It is managed under the aegis of the company and its management, but it is not part of it. For example, when the balance sheet of a company is drawn, which has an exempted provident fund, nothing that is part that which is the asset of that fund ever forms part of the asset of the company. Okay, it's separate, it's different. It is just within the same premises, but totally independent, just being managed under trust by the company, because the company has promised, and that is why they got the exemption, that they will give benefits which are better than the what the EPFO can give. In fact, that is the act says at least the same, but normally they will not get permission unless they promise something better, which they usually do. So when the section says from the fund, yes, it is from that fund, which is either the exempted fund or the EPFO fund. But now let us look at that fund. What is the balance sheet of that fund? How does that look like? It has a receivable from the employer. So that is an asset, which means that at the same time, the liability towards the member has got created. It may or may not be an entry yet, depending on whether the books are up to date or not, but that is how it is. So the employee has to receive from that fund, which in turn has to receive from the employer, which is a priority under the EPF Act. That is how this section has to be read. Okay. So section 36 excludes all those which actually are not assets in the books of the corporate debtor, but in some manner or the other lying with the corporate debtor, either by way of goods under bailment or leased assets, for example, which have been hired, or payables. Not all payables obviously are assets in the books of the creditor, but only certain payables have been given the priority by law, that they shall rank much above that. So section 36 4A3 has to be understood here from the provident fund means that indirectly from the employer, directly from the fund from which it is due. Okay, any questions? Hello? Nitin, you can hear me, right? Yeah.
I can hear you. Yes, we can hear you, sir.
I get confused. Okay, Mr. Vishwanath.
Yeah, just one clarification. This PF dues include employer's contribution?
Yes, PF dues again. I think you didn't attend last session. So four components among PF dues: employer's contribution, employee's contribution, interest for any delayed payment, and damages by way of penalty, if any.
And interest on if penalty is not paid on time, interest on penalty also?
That is a separate issue. I don't know whether there is interest on penalty by itself, but they have there is a table under EPF scheme.
In one case, they charge the PF department charge them.
It could be. I don't often remember it. You have to go to that scheme whether penalty is also there is interest payable. There might be. Because everything is payable on demand. All penalties and fines. Otherwise, people will never pay it and say, sorry, no interest. 10 saal ke baad dunga.
Just one more question. In case of termination, for example, if the order is passed today during liquidation in favor of a workman, so in that case,
termination by whom? Termination by whom?
By employer.
There is no employer during liquidation.
No. It was before liquidation, terminated before liquidation. Then during liquidation, court passed order in favor of employee. That termination was illegal.
It is probably before CIRP itself, right?
Yeah. Before CIRP. Yes.
Okay.
Yes.
Yeah.
So
the termination has been held to be illegal.
Yes. And
same thing applies.
In that case, PF interest on PF from the back date, or it will be calculated. It will not be payable.
No, any illegal act.
Okay.
Means the clock is reset back to that day. So yes, sab karna padega. See, one has to suffer the consequences of illegality.
Yeah. So, for example, the termination was in 2013. So, interest will be calculated from 2013.
Yeah, because the employee who has been wrongfully terminated has not gained that money, which otherwise you would have got from the PF fund as a dividend every year.
Okay. Thank you.
So
Thank you.
you're not giving anything extra. कोई घर का नहीं दे रहे हैं. In fact, less than what they would otherwise have got. Reinvestment, because that is compounded. Every year that is paid. Whereas interest here is, I think, simple only.
Okay. Thank you.
Yeah, Mr. Vishwanathan, one second, Mr.
Sir,
Bhatia.
my question is, under section 7A, before the commencement of the CIRP, section 7A inquiry has been conducted to determine the dues from the employer. And the 7A proceedings were conducted and there was no appeal under section 7I or under section 7B review are not been done. The 45 days are elapsed. After 60th day, the appeal to under the 7A has also been come to not challenged. It became absolute. So in that situation, that employer-employee contributions are being held by the IIP. Sir, is it audible?
Sorry,
Sir?
yeah. I muted you by mistake. Sorry.
Yeah, no issues.
My apologies. Yeah.
See, actually, after the commencement of the CARP, based on the 7A determination, the employer-employee contribution, this is not an assets of the third party. How RP can, why in that case, RP has to pay immediately. Why he has to wait to determine on 14B 7Q? All will come only if you are not paying the money 7A determined amount. And any delayed payment under section 14B will come. 7Q automatically, it's a process, and 2 separate orders also been given. Given. But my question is, that's a 7A liability. Even during the CARP, if the funds, this is not the fund, it's a fund belongs to the third party because it's an employee's fund deducted from his salary and employer's contributions. Both are been, why the IRP and RPs are asking to file as a claim. It is not a claim, it has to be paid. It's a third party's assets. Why it has to be taken?
You have just made an extremely important statement of what it ought to be. Excellent, thank you. I was going to come to that. You already said that, but we will cover the questions and we will come to what you said, because that is at the heart of everything. Yes, Mr. Lahoti, you had a question.
Yes, I had a question on the previous slide. If we just go back one slide.
Yeah.
So as you explained to us just now that all the PF dues is supposed to be contributed by the employer into a fund, which is legally separate from the CD. So could this, so if my understanding is right, so is this understanding correct?
Yes, see, it has to be paid to either the EPFO fund, which is the central government fund, or an exempted fund if the particular establishment has been allowed to run a separate exempted fund.
Yeah, so in any case, it's a separate, maybe a separate legal entity, right?
Yes, it is.
And so whether this clause can be interpreted to mean whatever is there in the separate fund is okay, goes straight to the workman, but whatever employer was required to contribute based on the number of years workman worked with the employer, but the employer has not contributed to the fund, are those, so these are those dues that are supposed to be excluded from the asset of the CD?
Absolutely. Yes, the two are separate because what is already there in the fund is anyway not in the control of the employer. It never is. The moment it is like some, as if putting into the employee's bank account, but that bank account is held and managed by a trustee. Okay, treat it like that. It has got, what do you call that in when you have a lock-in period? Okay, it is the equivalent of a lock-in period. It is the employee's money held by somebody for a particular lock-in period. That is because the Act says so. So that money, the money in that account, because it is individually there, each member of the fund gets a statement right at the end of the year. What is the contribution available in their account? Now that is their asset. So that is never the asset of the company anyways. The moment it is deposited in that, out, it's no longer the asset of the corporate debtor. Never was. Okay. So now what this section 36 is talking of is that which is still payable. It can't be talking about that which is already paid, because that would be silly. I mean, why would an act of parliament state the obvious that what is not yours is not yours? So it's not saying that. It could have, a better drafting would have used the word to instead of from. But just that small error doesn't change the intent of the lawmakers, and not now, from beginning. Why they have used the word from, I think slightly convoluted thinking that from the fund, yes, because the employee gets money from the fund, doesn't get directly from the employer. It has to go to the fund, and then on due date, whenever that is, as per the eligibility criteria, when you can draw from the fund, etc., you will get it from the fund. So the money is due to the employee from the fund, but by the employer to the fund. So the money due by the employer to the fund is the one which has got priority, because that is first charge. Okay. So now, when you have not paid, okay, let me complete. When I as an employer have not paid that money, I'm holding that money in trust. It may not be in the form of cash, but because it is a charge, first statutory charge on my assets to the extent that I have. So I have to pay that first before I pay anybody else. For the IBC situation, take a normal situation. Okay, there is no insolvency. I mean, there is, but it is not under a statutory insolvency. Still, the employer has to pay that first, because that is first charge. Okay, over all other debts, it's like there is no exception whatsoever. So PF dues have been categorized again, because as that's why the precision fastener judgment is worth reading again and again, because it actually brings out the rationale of this priority in probably the best possible manner, that it is right to life, and right to life is about every other right. Right? First is right to life, baki sab baad mein aata hai. So that is how this is to be interpreted. Okay.
Right.
Yeah.
There's a follow-up question here. So may I continue?
Yes, go ahead.
So now, is the CD responsible only for contribution that he was required to be made, the contribution that was required to be made and he has not deposited, or he is also responsible for the interest on the contribution?
Okay. Principal and interest automatically, except that how is interest to be calculated? The moment you check with the PF department, they will tell you. See, once you file your return as an employer, or these are my people, this is what is their pay, and I have not paid from so and so date. As per me, the contribution is so much. Please tell me what is the interest. You have to ask them, they will tell you. Now, damages is discretion. Interest is not discretion. Okay. Damages by way of penalty up to the department, how much to levy, they've got a table, they can do so, they can waive the damages, right? And there are conditions for that. It is not blanket waiver, but in general, when it is a case of sick companies, the references in the act are and the scheme are to VFR, etc., or even restructuring, takeover by a third party. In all such cases, damages can be waived. So that's because that is not going to the employee. So the discretion is being exercised by the government through the EPFO that it may be waived in appropriate circumstances.
Is there any provision?
One second, Rekha, then Mr. Srinivas. Yeah, Rekha.
Sir, is there any provision that
Mr. Srinivas, hold on.
Okay.
Rekha first. Yeah.
Yeah, Raviji, I have two questions. As you just mentioned that the damages is not the amount which goes to the employee. So here in this definition, it says all sum due to any workman or employee. Then how the damages becomes a part of this, number one. Second thing is, if the damages is the part of 17B in totality, like PF dues, and it gets a super priority. However, the same is not being distributed to the employees by the department. Then why it should have the super priority? And the third question is
not distributed by department to the employee. They have no such right. They have to.
The damages part also they will distribute to
No,
the
no, no.
employees?
Damages is not. Damages is not the
Yeah.
employee's money.
Yeah, so in that case, why it should have the super priority? It can be in other creditors.
Oh, okay. Why? Okay, this is dealt with in a separate judgment. That very, very nicely put. I like the way it was put there. One of these, I think it is SK Pharma, if I remember rightly, but or Maharashtra State, one of the two. They say that if you allow damages to be, because it doesn't go to the employee, KRA, it should not be payable. Every employer will never pay anything in time. So he says penalties are part of law. Okay, they are imposed. So the employer is bound to do it. Whether the employer is in a situation where the employer can claim waiver and be allowed waiver, that is allowed. See, damages in case of companies which are in distress, because they have the powers, the commissionerate at different level, differently, they do waive, even in normal circumstances when things go wrong. And definitely in case of a scheme of BIFR, etc., there is a specific provision. Now, BIFR, as I said the other day, please read it as IBC. They will consider that. Everybody knows that IBC is successor to BIFR. So to that extent, there is. But there is another way of doing it. That is section 53. We'll come to that. Okay.
Yeah. I was thinking that why it should.
Okay. Let us finish the question. Yeah, Mr. Srinivas first.
Yeah, sir. My question is there any provision in the Provident Fund Act that the damages under 14B cannot be more than the amount due under Section 7?
Yeah, you read the scheme, not the act. This is addressed in the EPF scheme. That's a separate scheme which is promulgated by the central government based on the delegation under the act. So read the scheme, you will find it.
Right. Okay. Thanks.
Yes, Mr. Shikhar Jain.
Hello.
Go ahead.
Am I audible?
Hello.
My question is whether once the employee has been wrongfully terminated by the CD and subsequently he has been restored by the court, and he has and for the salary, for his wages, he has obtained the degree in favor of the from the asset of the company. Whether the liquidator is required to pay the full salary wages or the PF portion of that wages only.
Wages was one second. I got your question, Mr. Jain. Were you here throughout or you joined late?
No. I have joined late.
Okay. This is what we covered in the LML judgment, that 2 years wages, prior 2 years wages will be covered under priority 1A, and anything beyond 2 years wages, okay, will be 1F, but PF will be above 53 as usual for the entire amount. Okay.
Ravi ji, I have a practical.
1 second. There are.
Yeah, if there are, okay.
Mr. Navanda.
Yes, sir. Say before suppose I have received a claim from Provident Fund, which includes 75 towards Provident Fund and 25 to damages. So I have to write to them a letter that I will be paying 75 first and 25 will fall under the F.
We will cover 53 की बात कर रहे हैं, हम आएंगे उधर. Mr. Lavati.
Because it is a damage. Suppose
got it. We will cover. Specifically the issue of damages we will cover. Yeah. Mr. Lavati, any specific question?
So I think my hand did not go down from last time I asked.
Okay, fine. Mr. Vishwanathan?
Yes, sir. See, actually, my question is again, 14B I slightly differ from what it say it is not benefiting the employees. The reason is...
1 second, we will come to 14B.
No. Yeah,
we will come. Okay. So we will...
See, what exactly happened, sir? Suppose it's a deterrent action. Suppose any employee doesn't pay.
If your facts are very detailed, we may not have time to do that. You can talk to me separately.
I want
go to the crux straight away. What is the issue?
See, actually, what I have already told, the 7A disputes are not an assets of the corporate data. So that
Yes.
has to be paid immediately. Why it has to be called on as a claim form, and then from there it has to be go to the resolution.
Okay, I told you I will cover that. Wait, that's very important. Definitely I will cover that.
Yeah.
Because that is the obligation of the RP or liquidator, how
Because
they should be doing their job. Absolutely, very important. We will cover that.
Section 18 of the
No, we will come. I'll come. Don't worry. I will come to that. Mr. Lunkar, any specific question?
There are two parts. One which I have already mentioned and which you have stated you deal with it later regarding payment of interest on late deposit of PF for the pre-CRP period. The other is that that EPFO has carried out an inquiry and has determined that certain amount is payable, and they filed a claim. Obviously it is, it is much after, and the company is under CRP, and the claim is filed, much after that 90 days period. So how that claim should be, dealt with? That is,
Okay. Welcome. Okay. It's general claim beyond 90 days. There is an issue in normal course. Okay. We will come back to this now, section 53. Okay. EPFO or any provident fund, exempted fund also. But EPFO will take us because that's the majority. Is it to be treated as a private party or as a government? Okay. Generally, we will all agree it is government, right? It is set up by an act of parliament. It is under the administrative control of a specific ministry. It calls itself, even its website is .gov. So I think this is something which all of us can agree that EPFO is government, which means that dues to the government should fall under 1E.
EPFO should fall in F.
Huh?
It should fall in F. Why EPF should fall in E?
No. One second. If it is government, it will fall under 1. If you say it is not government, then 1F. Okay. 1E, pari passu between government dues, etc. Is 14B, now we come to 14B because we have dealt with 7A and 7Q, they belong to the employee. So they are kept out. Okay, super. 14B. If the company is not under CRP or liquidation, then even 14B is payable in full, unless waived specifically. Now let us say a CRP situation. Now the RA has two options. Okay. One, to say that I will pay 14B to the extent payable under section 53(1)(e). You calculate and tell me, Mr. RP, what is the amount payable. Knowing fully well, as a RA, by my commercial wisdom assessment, I know that by the time it reaches there, it will be 0. So I can deal with it under IBC. Or if I'm not too sure of that, I can also say that I will seek waiver of that specifically. I will put it in my resolution plan. I know that the AA cannot give that waiver because the AA is not the authority for giving it, but I will seek a recommendation of the AA, and then I can go to the PF department and say, along with this, that please waive 100% because my resolution plan is equivalent to a scheme under BIFR, and under which you are fully authorized to waive 100% dues. Invariably, if everything else is paid, it may take time, but PF department usually will do. Okay, option 2 would be when something still remains under 1. But as a knowledgeable RA, if you know that, okay, there's nothing to be by that time, so I offer to pay liquidation value. In both cases, I am following the law, either by addressing it under IBC, by offering to pay liquidation value, which I am entitled to as a plan, because the minimum payable, or of course, if my resolution plan amount is such that it is beyond liquidation value, etc., it might have something, but those are extremely rare cases. We know that in general, those things don't happen. Otherwise, I have the option to seek waiver, and then the IBC itself allows me time to get compliances, etc., 1 year, 2 years, whatever specific provision is there to seek government permissions, which this would be equivalent to that, getting a seeking waiver from EPF. So both the options are available to address it. Now, this is my opinion. I say because whatever I have read about EPF, it is effectively a government body. It is. It may be performing a welfare function, but it is not performing a commercial function. To that extent, it is coming within the overarching sovereign functions of a modern state. It is linked to provisions of the Constitution, directive principles of state policy, as somebody else said, Article 21, right to life. So since all these are there, it would not be wrong to classify EPFO or even an exempted fund case, because even their penalty is payable to the government and not to the fund, in such to the central commissioner. So I would treat it as a government dues, the 14B damages, and deal with it accordingly, because that is what I have. This option, in my opinion, is perfectly legal, that I can do it as under IBC section 53, read with section 34 for a resolution plan, or by seeking a waiver separately under the EPF Act, because that is also allowed. So my choice. So yes, so that does that answer some of the questions related to 14B?
But that is about the CIRP process. What in case of liquidation? Then again, in liquidation, one can seek the
in
waiver.
liquidation, LV is automatic. No, 53 anyway applies. CIRP, there is the question to the RA of option. In liquidation, there is no option. It is 53. There is no question of seeking waiver. Liquidator doesn't go anywhere. Liquidator is only an auctioneer, effectively. Liquidator doesn't have to seek any permission. He goes by 53 and 53 only. RA has options. RA need not follow that. He need not take the benefit of, see, the RA is bound by the minimum payable for operational creditors, etc., as whatever the law says, section 30 subsection 4, if I remember rightly. But liquidator has no such option. For him, those 30 is no longer available, na? Only 53. So in liquidation case, it's a very straightforward, simple. You classify 14B claims as government dues, automatically it will fall here.
Yes.
I mean, this is my opinion, but I don't think I'm wrong.
Sir,
Yes.
is there any judicial approval for this kind of treatment, or no? Or is there pending any pending?
I am not, you know, the rule of law says I don't have to lead negative evidence. Is there anything against it? If not, then this is correct.
So why I'm asking, sir?
This is how we have done in one of the client, wherein we considered 14B as central government or state government liability under 53. And there was no issue raised by the department also.
Nobody will dispute that, because the entire EPFO is managed by government officers under government department, a ministry. It is a creation of a specific statute, and it talks of penalties, damages by of penalty. Now only the state can levy penalties, right?
Yes.
Private parties cannot levy penalties. You know, they are not enforceable under, you know, statute. Even though you might have what you call as penalty in a contract, but really speaking, that is in the form of contractual damages. Yes.
So my
Navandar, yeah, boliye.
So my question, if I have received a claim of 100 rupees from Provident Fund Department, which consists 75 rupees Provident Fund, 25 rupees damages, 14B. Now I have to, before distributing, I have to write to them that I have received a claim of so 75 I am considering as priority, and 25 I am considering as a non-priority item under section E, and I will be distributing you 75.
Yeah, always you must intimate any claimant as to, I mean, that is good governance, right? Though
Yes, so
the
that
act or the regulations don't say it, but it is always best to intimate where they will fall and how they will be paid.
And so that accordingly, I write to them and wait for their response, or I distribute the
No,
balance
you don't have
amount.
to. You are only stating a fact of law. You don't. There is no requirement of waiting for a response. Because see, if what you say is what is legal, where is the question of somebody else's? If they dispute it, up to them. But let me tell you, by practical experience, there are some people who will, you know, bear me up on this. Certain Provident Fund commissioners, Mr. Jain, certain Provident Fund commissionerates actually file separate claim form for 14B because they know that it is separate. All of them are not doing it yet, but apparently what we believe is that the Central Commissionerate has intimated all these judgments, etc., to them and told them to file claims accordingly. So, sir, some people file two separate claim forms. They file one for the contribution and interest and another one for 14B damages.
Okay.
Yes, Mr. Lunkar.
Ravi Prakash, sir, I have a small query, sir. We have gone through.
One second, Mr. Rajesh first, because this is your first question, so you get priority, super priority.
Sir, I have a small issue, sir. Sir, the CD was non-operational from 2013 onwards, and the liquidation order was passed in 2021. And the PF department has a claim of 5 crore rupees, referring to so many damages and all these things. Now under section 53 waterfall mechanism, precisely where it falls, sir? It falls under E?
No, it all depends on the claim. Is it 7A, 7Q, 14B, under which one?
Sir, it is, but it includes all the three, sir.
But each one falls under a different one. No, that is what we have been talking about. 7A and 7Q are above 53. Super priority. Okay.
But where it is mentioned in the section 53, nowhere it is mentioned that they are super priority, sir.
When did you join this meeting today?
Sir, I joined a little late, sir.
Little late means totally late. Must be last 5 minutes. But I saw your name right from beginning. I remember seeing your name at 5 o'clock itself. So either you have not been listening. See, I can't repeat the whole Ramayana to you again. Talk to me separately. Mr. Lunkar.
The query is that the company, is operational. It is under CRP. Now, of course, there are, liquidity issues, but it is not that the company doesn't have the funds. It is having the funds, operations are being carried on. Now, those employees, some of the employees who have retired, they are claiming, that the gratuity amount should be paid to them. And it pertains to mostly, for the past years of service, which are prior to the commencement of CRP. So how should that be dealt with?
Well, interesting. Gratuity is slightly different, not totally different, but there are differences. Did you attend the last session, 2nd August?
No, last session I couldn't attend. Yeah.
Okay, because that is when we covered these laws as to what the provisions are, what is the difference. What I would suggest is, because this question you can get an answer, the recording is available on the YouTube site. So go through that. And gratuity, see, every due amount that falls due, it either has accrued before CRP or after CRP. So accordingly, that is the dividing line. So does it become claim as on CRP commencement date or part of CRP cost after that, or part of liquidation cost? So accordingly, you will have to calculate it. Provident fund accrues on a monthly basis. Okay. And is also payable on a monthly basis, not to the member directly, but to the trust. And then after the lock-in period of, as per the scheme, the member concerned or the employee concerned can draw that. Gratuity is different. Gratuity accrues on an annualized basis, but payable only on termination of employment, either by resignation or retirement, superannuation, or death, disability. So there is this difference between the two. gratuity money need not actually be separately paid on a monthly or annual basis. It just has to be recognized. Many people don't even recognize it as a liability, they show it as a contingent liability. Because gratuity is not payable if 5 years service is not completed, continuous period of time. So to that extent, the two schemes are different, but there are certain commonalities. Both are social welfare legislation. Both dues have a first charge on the assets of the company in an insolvency situation. Both dues cannot be attached by a court or by way of a decree or otherwise, or by any other authority. However, gratuity can actually be forfeited under certain conditions, whereas PF cannot be. Okay, so PF is like up there, gratuity is a little below that. Okay, right. Okay, this is a quote which I saw just a few days ago. This is by Justice Chandrachud at the 11th convocation ceremony of the Gujarat National Law University. And it's relevant for us as IPs to understand this before we jump into filing frivolous litigation at the drop of a hat. Justice Chandrachud here says there continue to be laws as well as lack of regulation, okay, which push the marginalized deeper in the pockets of marginalization. That means that those who do not, who are poor or otherwise not able to access the fruits of development or justice. There are laws which actually, create such barriers to them that they are not able to, get the benefit of a welfare registration or access to justice when needed. He is telling the students that at many points in your life, you will realize, and we hope we also realize, because it's equally important for us, that what is legal is probably unjust in certain situations. That something is legal in the sense strict interpretation of the law as it stands on that day, but it could be highly unjust. And what is just may not always be legal. So it is important to remember the differentiating parameters between law and justice. So niti, which is law, it does not always result in nyaya, which is justice. Okay. Something I think IPs need to remember this, all IPs, whether we are doing it as an IRP, as an RP, as a liquidator, as an advisor to an RA or to a creditor or in whatever role, even otherwise, that these are the things that we need to remember, that we have to have a perspective which goes to meeting the ends of justice rather than against it. Okay.
Sir, you will be sharing this PPT or?
Yeah, I can share. Right. Whenever you want. I will send it because this is not what you call a registered event. So you can send an email to me. I will send it to you. Whoever wants it.
What's your email ID, sir? And can we reach to you for more, detailed sort of discussion?
Absolutely. Anytime before leaving, I will put my number and ID in the chat box. You can note it down. Okay.
That would be great, sir. Thank
Ravi
you.
can I ask probably a last question?
No, you asked them. There are two things to address, your question and one more as to duties of RP. Okay, I will come to that first. Let's see. Finish your question, then we will come to that.
Yeah, it's a practical question. The company is in CIRP and last few years the operations are closed. So few years before the balance sheet got an access by RP, and in the balance sheet there is some liability of provident fund. Filed a 19.2 application to get the details. There is no cooperation, nothing. But then finally nothing happened. The company went into liquidation. There is no claim received from the PF department, and there is no information with related to the breakup of liabilities and this thing, how the liquidator would discharge his responsibility in terms of the liability which is sitting in the books, PF liability.
If you mean to say that the books show that certain amount
Yeah,
is payable to
yes,
the PF
yes.
department,
Yeah.
except that you don't know who,
Yeah.
under which names that is payable.
Nothing. There is
Okay.
no cooperation from the.
What
the
about
CD.
what about the PF department giving
We
you
wrote the
discharge?
letter. We have no claim. There is no information. There is no response. Nothing. Now all the sale proceeds, I mean, assets have been sold. There is money lying. So in that situation, what the liquidator should do?
Okay, I'm you know saying this offhand, whatever basis. There is a fund created by the IBC.
Yeah,
Separately
I thought so.
For
Yeah.
money which has not been claimed but may be claimed at a later stage.
Yes.
Okay. So I think the best way for you, identify that number from the thing, but don't pay it to the PF department because it may not be payable.
Correct.
Because okay, it is just there. So in cases where you are not sure whom does it go, but it may possibly go to that, then once you could approach the A seeking permission to deposit that amount with the IBC.
Mm-hmm. What I did is that I deposited this amount with the IBBI. I wrote a very huge submission with all the evidences and efforts put in by me as a liquidator, that since I put in all these efforts and I'm not successful, and there after the last resort is to deposit just with the IBBI, because any which ways IBBI also will not be privy to the information to distribute this if somebody is claiming. I mean, who is going to claim and how they are going to distribute. So the inquiry came in terms of why this amount has been deposited with IBBI. Is that the? Yeah.
I can understand. Who wants extra work?
Yeah, I mean, हम क्या करें? हाँ, जबकि law में तो clearly लिखा है,
No,
it's about unclaimed dividend and distributed, not about the PF.
Yes.
And they
see the word dividend is unfortunately borrowed from the Companies Act.
Yes.
Where dividend is the amount distributed to creditors under
Right.
liquidation.
Yes.
And it could all. So it has to be read in the same manner. So this is unclaimed, money. How does the IEPF do it? IEPF money becomes government money after a certain period of time, if no claim is received. But because you can't be holding it with you, so they say you put it in our fund, whoever has to claim will claim it from us. And they will have to go through the same verification process at that time. So if there is any claimant in future, but if you send it directly to the board, because it is not exactly in line with the letter of the law as it is, they may also be confused as to under what, why should they take it? If they take it, is it okay?
Yeah,
so
finally
probably, ideally, if you get
Yeah.
a direction of the NCLT that you shall deposit with IBK, you are protected because there is a judicial order.
Yeah, they asked me that have you taken a permission from adjudicating authority? I said the law doesn't ask me to take the permission. However, when I filed a dissolution application, I did mention about all these things, and it's on the record. And later, adjudicating authority also took the cognizance of this, and they mentioned in the dissolution order. So that's how we closed it. And then I intimated IBBI.
That's fair enough. But when in doubt, interpretation. See, law will not tell you everything. Okay, some things obviously are procedural, maybe, or what you call common sense, and then you shouldn't run to the AA for everything. But here it's a bit of it's money, right? When money is involved, better to be safe and take the direction, because the law says when effectively it says, though it's not so many words, that liquidator for any doubt can go to the AA for direction. So
Yeah.
Easier way to do it, nothing special
Right.
about it.
Okay.
Okay. Yeah. Now, two things. First is the one which Mr. who raised it. I said very important point. That was, what is the role of the RP or liquidator? And if the PF department does not file a claim, does it extinguish the rights of the underlying members to whom it is due? So this is where the problem is, that Really speaking, the RP is supposed to comply with all laws, which means the law of PF, which means you are stepping into the shoes of the employer, which means that you are obligated to calculate everything and pay. You don't have to wait for a claim from a government department, which otherwise has no right on that money. It is only a trustee. And if the trustee fails in its obligation for whatever reason, good, bad, ugly, we don't get into that. The RP and liquidator are definitely obligated to make every effort to get that number crystallized, even if there is no claim. And during CRP process, you can put it in the IM and say, claim not received, but based on the books available, all the information available. It could be provided in the books X amount, not provided in the books, but calculated by RP, Y amount. And that's it. I mean, that it has to be addressed because it is payable, even if it is not claimed. In once it is payable, then all effort has to be made and all laws have to be complied with to the best of the ability under the circumstance. Where no records exist, naturally, you can't do it. I mean, it doesn't ask you to create records. The law says if it is there, you need to do your due. So, as somebody asked, 7A, 7Q. 7Q is a bit difficult. 7A is known to the employer if the records are available. Definitely must be calculated to the extent available. 7Q, seek from, file the return with the EPF and then seek the amount from them. What is 7Q? 14B, don't talk about it. If they ask you, then they. Okay. So, right. Okay. So that brings us to an end of today's session. If there are any further questions, anything which I had promised I will cover, missed out. Okay, fine. So that I will take that as that there is nothing left. Thank you all very much.
Thank you, Ravi ji. It was a very wonderful session. Thank you so much.
Thank
you, Mr.
Thanks,
Ravi.
thanks a lot.
Thank you, Ravi ji. If you can share your coordinates, please.
Yeah, I will.
Please share your contact number and mail ID.
Right. So Ravi sir, thank you very much for your session. Participants, thanks to you also for taking your time attending this session. As I said that this was one of the topics that IBB in specific told us to take forward in terms of taking, having sessions on this subject. So in case you have any further subjects that you would like us to conduct sessions on, then I'll be very happy to have those. You can mail your suggestions at my email ID, which is nitin.satija@icsi.edu. And I think, as Sir said, Sir shall be sharing his PPT with all the participants. We'll give the details of the participant to Sir. So I think with that, we can end the session. Thank you very much.